I have Andrew Hendrickson testifying on behalf of ACLU of Texas, and you are neutral on House Bill 44. Is that correct?
That's correct.
Thank you.
Thank you, Chairman Van Diever. Members of the committee, first, I just want to start by saying pregnancy is too complicated of an issue to legislate. We've heard plenty of stories this morning proving that the only way to actually ensure that women have access to the reproductive health care that they need would be to repeal these bans. But I understand that it's not where we are, and that's not the bill in front of us today. So I wanted to spend a little time talking about why the reference to the 1925 law matters being in this bill. Just to flush out where the legal groundings are. So when the case was tried about the applicability of the 1925 amendment, Judge Pittman found that the legislative findings in SB 8 and the trigger ban bill were insufficient to revive a law that has not been repealed. And even assuming that the recitation were possible, Texas legislature has not chose to reenact the pre-Roe laws because that were not repealed because they did not make it a statutory amendment, and that does not render the decision in the McCorvey case, which is the case where the Fifth Circuit found that the 1925 law was repealed by implication. So essentially what the court is getting at is that by making a statutory amendment to the 1925 law, you're changing the legal analysis about whether the legislature reenacted it. By only stating it in the legislative intent that it was reenacted in those two bills from 2021, the court found that that wasn't enough because there was no substantive change to the actual underlying statute. I also want to mention that the furnishing the means provision we heard a little about earlier, I think absolutely raises serious First Amendment concerns and unconstitutional violations of the right to travel out of state to receive care. Legal standards review have changed, first of all, since the Roe decision about the plain meaning being more relied on. And also two examples just to cite of this happening, or of people pushing for a version of this where people could be punished for furnishing means. One would be that the Paxton filing itself in the case suggested that buying a bus tickets to New Mexico would be a violation. And then there was the Sidley Austin LLP letter from several members of this body suggesting that funding out-of-state travel for abortions could subject them to 2 to 5 years in prison, and inciting to that. In that letter to Sidley Austin, they cited the 1925 law. So there is clear, excuse me, I'm over it, but.
Okay. Thank you, sir.